Hello, my name is Christine DeMaria. I'm a partner with Husch Blackwell, and joining me today is Liz Rowe. She is senior counsel with our firm. Before we get started, we wanted to run through some housekeeping items. First of all, you'll notice at the bottom of your console, there are some icons, application icons. Please use that throughout the webcast. If you happen to have some questions during the presentation, use the question box and submit it through that question box. And we are going to do our best to try to answer those questions during the presentation. But if for some reason we are able to, we will get to it afterwards and you'll get an email from us with a detailed answer to your questions. So, and then finally, at the end, you'll find that there will be a survey. We very much appreciate your feedback on this. Anything we can do to improve our program and to provide you with additional information, we're open to, and we really do appreciate you joining us today and giving us the feedback. So let's get started. I think that's all the housekeeping for now. Today, we're going to cover a topic. We call it, what happens in DC doesn't stay in DC. And isn't that the truth? And the impact that this is going to have on our farm succession planning could be significant. And it could have a direct impact on the ability for you to implement a successful, viable plan. Family farms are a very important part of our economy. The succession planning is about preserving an agricultural legacy and maintaining it for our farm. It is, for the family, it is much more than a business. Many of our family farms have been in family for the generations, and they are part of the family. So businesses have to implement a succession plan, and just like all businesses, a succession plan can be difficult. We deal with hundreds of family farms. They all have very similar goals. They want to continue to preserve the farm. They want to treat their children fairly. They want to achieve some harmony. They want to be able to get together for holidays. And many of them also understand that their experience, they've seen it personally with their own family. They've also seen it in the community, where if they do not implement a good plan, it can fall apart. But regardless of that, it still delays. And I just read an article the other day where out of all the farms, 97% of those farms are family farms, and only 11% have implemented the plan. So if you look at the goals the family farms have, they have the family goals of implementing a plan, and they haven't done it. So what's going on in Congress right now might mean that they have to act a little sooner. Without planning, you have the risk that assets are exposed to creditors and divorce, liquidation of assets because of poor succession planning, failure to train the next generation, and that is so important. You are trying to implement a plan that's going to last through multiple generations, and it's important for that to happen, and training the next generation is very, very important. And of course, family disharmony. From a legal standpoint, what happens if there's no plan? There's probate, guardianships and conservatorships for minors and for adult individuals, and some of which are running the farm. Costs and taxes go up, and the business succeeds to the wrong people. I always tell clients that you're going to have a succession plan. The question is it going to the right person? It's going somewhere. And then, of course, the family conflict, that the uncertainty and the inability to put something together and get a plan together really does cause some problems with families. So with all of that said, what has changed? I'm sure many of you have heard this before. I'm sure many of you have implemented different parts of your plan. The difference now is laws are going to be changing this year. We're pretty confident in that. What that is, we're not sure. Liz is going to go through this, what we are hearing. But the important part to that is this is going to require some action, at least some evaluation from our client standpoint. So I'm going to turn it over to Liz.
Wonderful. We'll first go through the current tax rules as they stand today. For those, there's an annual exclusion, gifts that can be made. You can give gifts to individuals, as many individuals as you like, $15,000 per person per year. If you're married, you may give joint gifts of $30,000 a year. These gifts fall under the gift tax exclusion amount, and you will be able to give those gifts without having to file a gift tax return. You also currently have an unlimited marital deduction, as well as gift tax and estate tax exemptions at an all-time high of $11.7 million per person, and a generation skipping transfer tax of the same amount. But as Christine mentioned, these are likely to change.
Things are changing.
And these rules are in place currently. The 11.7 million estate tax exemption is scheduled to reset on January 1 of 2026 to $5 million. But we're reading and learning and talking with other advisors about the change may be happening this year, as Christine mentioned. And Biden's proposals have even mentioned going back to a $3.5 million exemption amount. This is just a chart. It may be a little difficult to read, but it's some of the proposals that are in the works for possible transfer tax system changes. Some highlights include estate tax rates being raised from 40% to 45%, possibly eliminating the step up in income tax basis. And these are just a few items in the first proposal. There's also another proposal that's out there now, the 99.5% Act, that adds additional changes that may be in the works. How can the government change these tax laws? Through the reconciliation process. As you know, the U.S. Senate is now split 50-50, and the Vice President will break any tie votes. The Senate filibuster rule allows any senator to filibuster a vote, and that means most of the time when you think of a filibuster, it's an extended speech on the floor of the House or Senate, and this kind of delays the legislative process. However, with a filibuster, you need 60 senators to end that filibuster. There are exceptions, however, and budget reconciliation only needs a simple majority to be pushed through. The Democrats in the House and Senate just passed a COVID relief bill using this reconciliation process, and the parliamentarian has indicated additional amendments may be made through reconciliation. So the consensus is there will be more changes to the tax laws coming very soon. Can these changes be retroactive? That's a good question. What does this mean, and is it likely? Retroactivity is a possibility, and Congress may have the ability to enact retroactive tax legislation, which would limit the ability to front run any changes that are implemented later. Retroactive taxation is possible if it's rationally related to a legitimate legislative objective. And case law has shown us that revenue generation is such an objective. The general consensus among practitioners is that retroactive legislation is possible, but unlikely. We think that these changes will most likely be part of a larger bill that includes some income tax changes, and they're harder to make retroactive from a practical standpoint. So retroactivity, however, may impact any gifting techniques. Now, just as an example, if a client makes a gift, let's say today, as you know, the exemption amount is $11.7 million. A client makes a gift of that $11.7 million on May 1st of this year. Then Congress passes new tax legislation that reduces the gift tax exemption amount from $11.7 million to $1 million and makes it retroactive to January 1st of this year. The client has basically made a taxable gift of $10.7 million under this scenario. Again, the consensus is we don't believe the changes will be retroactive, but we're not sure at this point. And steps can be taken to mitigate the risk. And we are working with individual clients about specific techniques for their situation.
And I do think the farther it gets from the first of the year, I think it's less likely, but we're just not sure. So as Liz mentioned, that's out there. We want to make sure we explain this to clients as a risk factor when they make their decisions. There are ways to mitigate it, and it's an evaluation that you should always have with your counsel to make sure that you evaluated every possible scenario. So when we are implementing these rules, I think it's helpful. There's a lot of complicated tax rules. It helps to see it with a case study. So this is a typical family farm case study that we would see. You have mom and dad, Bill and Mary. They have a family farm that's been in their generation three generations. They've been in the family for 3 generations. They have 2 children. Susan is a professional. She does not work on the farm. And John is the heir apparent. He is active. He has some own farmland, and he also works with mom and dad. Susan is married to Bob. And Bob really wants to be involved in the farming operation. And that isn't the sentiment of Bill, Mary, or John. They want to be respectful to Bob, but they do not believe that he would be an important or an added benefit, provide an added benefit to their operations. So in this situation, a typical estate, Bill and Mary have their residence, their farm equipment, farmland of about 20 million, bank accounts and stocks, and then they have some other potential business assets that have some growth opportunities of 2.5. Collectively, that's $28 million. In all of these situations, we always want to look at, since it's a business, who's going to run this? You know, what happens? We know we've got Bill, Mary, and we've got John. Susan's not active, and then they don't want Bob. So that's an issue that we always come into play. And since this is, right now, everything's in Bill's name, you have to evaluate that. And again, we do not want, they don't want it to inadvertently go to Bob. So the issues facing this client, we've got to make sure the assets are titled correctly. You've got to make sure that the risk of divorce, losing the farm, and creditors are mitigated. You've got to make sure that there's a succession plan in place, who's managing it, and then the big gorilla in the room, the estate tax. In this situation, if we go through under the current rules, you've got $28 million. That is the value of their estate. As Liz mentioned, the current exemption is $11,700,000 for each individual, which is a combined $23,400,000 exemption. That is the amount that Bill and Mary could pass to the next generation under current law. If you deduct that, they've got $4.6 million that is subject to estate tax. That's under their current arrangement and under the current law. 40% tax means that as it currently stands, they have a $1.84 million tax bill as it currently stands. So let's make it even worse. What if the exemption goes to $3.5 million? So we still have the $28 million estate. The exemption amount is $7 million, $3.5 million for each Mary and Bill. That's a $7 million exemption. That would leave a $21 million amount available for estate tax. And at a 40% rate, we're talking about an $8.4 million estate tax. And that's huge. So what should these clients do? So this is a common, as we said, this is typical. I mean, there's sometimes more zeros, less zeros in different asset base. They may have some entities, but what should they be doing? So our firm takes a multi-step approach when we look at this, and this is every client. Now with the new law, and you'll notice later we'll talk about this, we're gonna have to reprioritize things a bit. But the first step is just looking at the core documents. That's number one. The trust, the will, healthcare directive, and living will. That's the ground floor. You always want to make sure you get the documents in place because that is who selects making decisions on some of the assets. Second step is to review those assets and then determine structure, entities. How is it? Are there existing entities? Do we want to restructure it so that we're maximizing discounts? And then the third is figuring out who receives these assets if we're trying to implement a succession plan. And that includes establishing trusts as well as transferring the assets to that trust. It's a two-stepper, really. Step 3 is because you're doing both steps. And then finally, other considerations. And those involve charitable planning. We have clients that are very charitably minded. So these complement the overall plan that we're talking about. So we want to make sure we're mindful of implementing this. And I will tell you, in every one of our clients, they're all different. So while we look at these steps, this is kind of an analysis. We always want to make sure we're mindful of how the client, what their goals are, and implement it accordingly. And as I mentioned earlier, Step 2 and 3 now are getting more attention because of the time, because we are really getting close to changes in the law. So I'll turn this over to step 1.
I will briefly discuss the step 1 core documents that you should have in place. These, as Christine mentioned, are the ground floor important documents during a person's lifetime at disability and then also at death. So whether a client is worth $2 or $2 billion, we generally start with core documents. And as she said, we may have to move the steps around currently because of the potential tax law changes or do things simultaneously. But core documents are extremely important for clients who own farm, ranch, and ag businesses. They help you know who makes decisions, again, at disability and at death, and also who will receive the assets. Core documents include a revocable trust, a pour-over will that pours over into the trust, a financial durable power of attorney, and a durable power of attorney for health care, and a living will. Also included in core estate planning documents, if clients have entities that are set up, are buy-sell agreements to spell out what happens if an owner, again, becomes disabled or dies. A will equals probate, and probate is something that is public, it's costly, it's time-consuming, and you need an attorney to assist you with it. It's also state-specific. If you pass away with anything in your sole name that does not have a beneficiary designation on it, then that item or asset will need to be probated. So that could include all types of assets: real property, real estate, and personal property. How do we avoid probate? Well, don't have anything in your own name at your death, meaning if you have assets, put a beneficiary designation on those or transfer the title now to your revocable trust. Assets may also be transferred to a revocable trust at your death through other designations. Now, the benefits of a revocable trust are that they avoid probate. They're private. You can do what you want to do. You can leave your property to who you want to leave it to, and it's a completely private process. You can provide and structure your revocable trust so that your surviving spouse, children, and even further generations of family members can be protected from creditors, divorce, and from estate tax, at least for certain amounts of generations. And you can name individuals in these documents to make decisions, again, during your lifetime at disability or at your death. And these allow for the division of farm assets fairly, meaning if you have a child who is involved in the farm, such as in Christine's scenario earlier, and one who is not, you may want to have different terms or leave different gifts for them in your revocable trust. Just kind of an easy way to look at this, a visual scenario of a revocable trust plan. Assuming that Bill predeceases Mary in Christine's, again, in her scenario, you can see at Bill's death, if he had any items in his own name at death, they would need to go through probate and they would pour over into his revocable trust. And the grantor, Bill would be considered the grantor, or another term is the settler, the person who sets up that trust. The trustee is the person who's in charge of the trust and the administration of the assets under the trust. And a beneficiary is the person who benefits from the trust, and they can also be a trustee as well. Now, in this scenario, at Bill's death, his trust is broken into additional trusts, and depending on the estate tax exemption amount at his death, either one or more of these boxes will be funded. And then at Mary's death, that there will be breakout trusts for each of the children, and they can have similar or different provisions. And then at that generation, estate taxes would be paid on the share that went to Mary's marital trust. As you can see, this scenario does not include spouses. Now, there are times when clients do want spouses to be included for their children's spouses, and we can customize that. But generally, clients like items to be transferred to their descendants by the bloodline, and this is what we've shown here.
So that brings us to step 2. And as I mentioned, step 2 now is getting more attention, step 2 and 3. This step involves looking at what you have, what a client would have, determining the existing structures, determining how best to structure things, and then if we can reduce the value using discounts, we try to implement that. So structuring the operations is very important. I mean, the first thing we would do is we look at the land. The land's a big piece of our farm clients' asset base. And it is a shiny, as I always say, it is a shiny object that if you are ever sued or if there's a divorce, that is the first place they love it. They don't want to own the land. They simply want to make sure they can access it and use it to leverage additional settlements. You want to analyze the operational entity and determine how to structure it properly. You also want to look at the equipment and the vehicles. Is it make sense to put that in a separate entity, or should we keep it as part of the operation? If there's existing entities, look at it to see can we structure it further by issuing voting and non-voting. So if we go back to what we just referred to, this is the clients. These are the estates of Bill and Mary have. I would be looking at the farmland as well as the equipment. And then the business assets that we mentioned, because that's one that could potentially grow in value, and we might be able to shift that out of their estate now. In our approach, as we said, we kind of call it a tripod approach. It doesn't always have to be this way. Every client is different. Every operation is different. And we are very sensitive that it's not a cookie cutter approach. So as I mentioned, the land, we typically will always recommend moving that land into a LLC structure or a similar structure to put a firewall around it. The farm operating entity can oftentimes it's an LLC as well, and we really evaluate that. There's a lot of factors that go into it. If a family has already established an account and we need to make sure that it is operating properly, and we don't want to be too disruptive for the clients. But you'll notice at the very top, sometimes there's a lot of assets in that operating entity. It could be a general partnership, which means if you're sued, you can get to that asset. So we may recommend setting up mom and dad owning a limited liability company as a single member. Why do that? Well, if you're sued on the outside coming into the operating entity, we want to put a firewall up so that they can't bust through the operating entity and get to the land. You'll notice we still have a land lease, so the operations continue. And then there has to be some thought about the equipment. I will tell you, we evaluate, there's several factors. How much transport's involved? What is the risk? If, does it make sense to just lease it to the farm operating entity? There's a 179 deduction question. Can we continue to obtain that, depreciation, et cetera? And there are ways we can do that as part of an LLC. We just have to make sure we're mindful of that. The operating agreement is also very important, and for farm families in particular. Over the years, we have seen situations where we might need to tweak it a bit to accommodate that farm family scenario. So one example includes a put option. What is that? Okay, so in a family that has, in our scenario, we've got Susan, who's not involved, and we have John, who is involved. Well, in a family situation like this, we may have Bill and Mary may say, let me do the operating entity. I'll give that to John. But the land, boy, that's family. We want to keep that and split that 50-50 in our trust so that Susan gets something and John gets something. Well, land is not going to be a liquid asset. So that money is going to be needed for the operation. So what we've done in the past is give a relief valve, we call it, so that if Susan, the kids may need to go to college, we get a little ability for her to say, I'm going to sell my percentage, a couple percentages back to the entity for a price. She'll get some money. There's not going to be a big disruption. There's not going to be family fights about it. And everyone knows in advance how that works. The other option, we do voting, non-voting, and that is a way to bifurcate a value, and is in illustrating that land LLC. You'll notice we have voting, it's 20 million. Well, if we can carve out most of that and make 95% of that non-voting, then we can use that interest to shift it to a trust. And then the cash rent option is one that, in our scenario again, if we have Susan and John, we've seen in situations where mom and dad pass, and then needs the land to farm. He needs to use that. Well, they don't have it in writing, what will happen sometimes is the off-farm child will come back and look at the farm and say, hey, we could probably rent this land more down the street. We can get more money for it. Well, if they do that, then it can destroy the operation because John needs it to run and it needs to keep cash flow running. So the cash rent option is incorporated to demonstrate an intent for the farm to be rented to individuals as a first option. If they don't, then it can continue to be rented to a third party, but it keeps some security and some continuity in place. And actually, we were involved in one that happened, and it really did help having that cash rent option in place. Discounting is when the estate tax is imposed, it's imposed on the fair market value of whatever you own at death. So as attorneys, we want to look at ways to argue that client owns something a little less, and we use discounting techniques to do that. That's lack of marketability and lack of control. So when we place high value assets, such as land, into an LLC, we can both provide firewall and then reduce the value. The way we do it is we fractionalize the ownership. If you have an existing entity, we recapitalize it so that it is into voting and non-voting. And we form various entities that also have voting and non-voting interests. And I'm going to illustrate how this works shortly. Entities, there are a whole slew of them. We've got family limited partnerships, general partnerships, which are usually used in the operations side. And again, we want to evaluate that. There are some FSA benefits to doing it that way, but that's usually where we would keep the general partnership. A general partnership is subject to creditor claims, so you don't get that same protection. And then the limited liability companies, as well as corporations, Cs and Ss. If you're recapitalizing a business, and we often find clients have set up an LLC, or they may have an S Corp to run the operation, but it's owned 100% by the client. In that situation, we would say, let's try to maybe restructure it and carve out that 90% so that we can get a discount for that. So let's run through an example of how this would work. So our example has the land, $20 million. If we transferred it to an LLC that has voting and non-voting in it, the discount that we'd argue, and again, this could be 35%, 30%, we used 40% for our illustration, that would give us a discount amount of $8 million. So that means the $20 million reduced by $8 million would leave us with a value of $12 million. So we've shaved off that $8 million from the client's asset base. So under that scenario, we have a $28 million original asset value. We carve it out, $8 million for the discount. Well, now we have a new estate value with the discount of $20 million. Well, the current exemption is $23,400,000. So we have now removed value from the estate subject to the estate tax. So there's currently no estate tax under that scenario. If it goes down, though, we are still in a problem. I mean, if it stays where it's at, you're good. If you go down, we are running against, again, the discount's still there. The estate value with the discount is $20 million. The exemption, if it goes to 3.5, is now going to be $7 million instead of $23,700,000, which means $13 million is going to be subject to estate tax. And at 40%, we're talking about a $5.2 million estate tax, a real number. So when you look at this, what's going to be sold? And I can tell you, it'll be the farmland. The equipment, you'll get depreciated. It'll be the farmland in that scenario that goes down. And that hurt. That can just destroy a business operation. So step 3 is we've got the entity, as we said in step 2. We've looked at the entity. We've moved an asset into the entity to maximize the discounts. Some clients may stop there. They may not need to move it out of their estate. Maybe their assets aren't at that level. We're not worried about it. But we've shaved off the value and we've provided a firewall. So now that leaves us with this next step. What if we may have to shift the value to the to the other family. So the exemption here, the goal is to use the exemption anticipating the tax law changes. Why use an irrevocable trust? Well, we have to give it to somebody. So we do not recommend giving it to your children outright. We have seen it. We have several cases going on right now where a child is married, goes through a divorce, and that farmland may not be reached entirely, but it is used as leverage. So instead of giving it to a child, we are asking you to create an irrevocable trust, which serves in the role of a child. So it's a little easier to raise than a child. But you have the irrevocable trust, and this protects against the divorce. It still allows you to control it, and you use your exemption to access it. In the scenario we have, you can give non-voting interest, so the control is still held with the family. Types of irrevocable trust, spousal lifetime access trusts, which are referred to as SLATs, beneficiary trusts, which are referred to as BIDETs, and life insurance trusts, which are referred to as ILETs. Given the urgency and some of the changes we're talking about, this step we find our clients establishing soon. They may not gift to it right away, but if you're going to make a gift, you want to have the entity in place, and you want to have the trust in place. And there are some rules we have to be careful about when we set up these trusts. We do not want to have an argument that the IRS can come in and say, this trust isn't valid or it should be collapsed. And so we want to make sure we do that. So those two steps are probably moved up a bit. And then the question becomes, what do we do with that interest? Do we make a gift with it? So I'm going to go through this scenario. We talk about the farmland. We transfer it to the LLC. The discount's 40%. And now we've got the value of this LLC at $12 million. So let's go through a SLAT, the spousal lifetime access trust scenario. A SLAT is an irrevocable trust. It's created usually for a spouse and the children. So in this case, let's say Bill creates something for Mary and the children and his kids and descendants, grandchildren. Mary can serve as a trustee. So how will this work? Okay, we decide now that the exemption is going to go back down to 3.5 million. We've established the LLC. We've established the spousal trust. And so we will now decide to make a gift of $12 million into the SLAT. It would be the non-voting interest, so it may be off a little bit, but for our illustration, let's say we gift that 12 million over. So it's gifting 20 million, but it's only going to be valued at 12 million because of that 40% discount. We've used the exemption before it expires. The way this is structured, the grantor can pay income from that SLAT if needed, and that would continue to burn down the grantor's estate. If he wants to access some of that money to pay taxes, there is a way to do that. And then we talked about the ILET. So you guys don't have a ton of trusts. You are able to use the SLAT to buy life insurance as well. And so that kind of incorporates multiple goals within that same structure. So after the gift, because we get the question, oh my goodness, I don't want to give away, I don't want to not lose control. We don't want to disrupt the operation. So if we implemented the plan we just talked about, here's how this will end up. It does three things. So you'll notice at the top, first of all, we got the land in the LLC. Mary and Bill, their trust will still have the voting. So they still control how that land works or how that land, the decisions regarding the land operates. You'll see that the farming operation doesn't change. They lease it to the farm. They continue to get the land just like they would if they owned it 100%. The difference is that SLAT will own the non-voting interest. So we have carved out some of that value, but we've tried to not disrupt the operation. And again, I say this, every entity is a little different, so we always try to tweak it to, one concern we have is clients do not like to have such a disruption. So we're very mindful of that. And we want to make sure we put a plan in place that accomplishes the goals without making more complication than is already there. Another bited technique that we are using a lot of, and it works for very well in certain situations, is something called a bited. So when would we use a bited? It is an irrevocable trust. The difference with a bited and the slat is after a bited is created, you have Mary and Bill could arguably be the trustees of that trust and access that money. So we use that quite a bit for individuals who are single or divorced because they don't have a spouse to have set up a slat for, and we also want to make sure that the assets we transfer in have considerable growth. So in the example we have, Mary and Bill have that $2.5 million asset that could pop in value. That would possibly be a great asset to put here. So if it grew to 10 million, you're shifting that asset value out of the estate. And then after it's sold, Mary and Bill can use it to reinvest it and not have that counted as their estate value. This is more complicated. It is a sale, so it's not a gift. So one of the reasons clients will ask us, well, why do I need to do both? Great question. If you are single, you probably don't want to do a slat. If you have an asset that you want to access later, you might want to do the bited. And the difference is on a slat, you can use a gift. On a bited, you cannot. So it is more complicated, but we are doing a lot of these for clients that have growth assets that they want to access later, and it works just incredibly well. The islet is a scenario too that we talked about, and as I mentioned, you can have the asset, the slat purchase life insurance. You can have the bited purchase life insurance. Both of those things can help complement and continue to incorporate everything in the plan. I will tell you, in our situation, we try to use the same entity as much as possible. So that's an example where I would probably have the islet. If we had a bited, if we had a slat, we would try to use the insurance for that. And it is still a liquidity vehicle, and that's why we would use the islet. So other considerations, as part of the overall plan, we got to make sure that we complement it, and there are other techniques that we can use. So charitable planning is a big part of this. And we have clients that have considerable assets, and they are contemplating trying to utilize it so that they're not sure what's going to happen. So the example with like the bited, we have a client who it may pop to several $100 million. Well, they can incorporate charitable planning as part of this so that it is not going all to their family. It might utilize a private foundation. These charities, like the private foundation is an entity that you establish for your family, that you continue to allow it to be used for your stated goals. You can incorporate a private foundation as part of the irrevocable trust. For example, if you've got strong charitable goals, you may want to do that. We also use it, it controls it. We also have charitable remainder trust, which is also a very good vehicle in some of these situations. But the point is, it's important to incorporate all of the planning as part of it. And so these are items we talk about. As we said, right now, 2 and 3 is up there, but it's very important as well.
Well, and also it provides the ability to teach the next generations about charitable giving and get them involved, particularly with private foundations or also donor advice funds, where those funds would go.
And that's a great point. And I think that's important to mention because oftentimes clients want to do this at a later time, and we will talk to them about maybe doing it now so that you can teach your children and let them know there's more than just inheritance. There's a philanthropic component to your goals. And I think it's important to do it. And it's also, let's be honest, if you have charitable planning or charitable goals, you can incorporate that as part of to avoid the estate tax. I mean, that will avoid it at the present time. That will be something that bypasses the estate tax. So in looking at this, we talked about this, use the exemption. It is going to change, and we know it's going to change. So you need to use the options to utilize that exemption. Gifting mechanisms, if you have it established and we think it's going to go away, You want to incorporate, maybe establish the irrevocable trusts, utilize it so that you're making the gift, but you want to maintain your control now. I want to show this to you because I think this is very interesting. We received this, well, I received it from a client. It's from Farm, one of the Farm publications, but this illustrates acres that are needed at each estate level. So if you look at Missouri, we're here in Missouri, so let's look at Missouri. You can cover 3,400 acres roughly. Well, for that 11,580,000, that's the exemption, can protect 3,400 acres. If you're in Illinois, it's 1,565 acres. In Iowa, you're talking about, 1,638. So you can protect that now using that exemption. Well, go ahead.
I was just going to say, and that's last year's exemption amount. So you can protect a little bit more currently, but as you're going to show in a minute, if it goes down, that reduces it greatly.
If you go down, I mean, look at that. Wow. Iowa, I mean, you've got 495 acres is all that's going to be protected based on the value. Illinois, 473, Missouri's 1,029.
It went down almost 2,000.
It went down almost 2,000, exactly. So you want to make sure you've got the various assets that are in place. You want to make sure you've got the mechanism to protect it. And I just think this illustrates it so clearly when you translate this amount into actual acres. So there is going to be some changes that could come about. So, I think it's important. I think we may have some questions here.
Yes.
Let's see. Okay. So the question we just received is, what are your thoughts on the risk of valuation discounting being curtailed or eliminated by future legislation? Well, in the two proposals we have seen, they are very likely. I mean, it is in the plan. And so how that is done, we're not sure about. They've talked about getting rid of some of the discounting, back in, when was it? They issued Chapter 14, which had some different rules in Section 2701, Section 2702, 3 and 4, that was designed to try to limit some of the discounting. So they're going to go there. Now, is it going to be retroactive and will we have time to adjust? I do think we will. The 99.5% plan that's out there that was just issued, Bernie Sanders, I think, published that, and even Biden's plan, both have those possibilities. So it is something that you definitely want to make sure we factor in. So our advice to our clients currently is proceed. Know that's a risk, but it's better to do something than nothing. Let's see. I'm trying to read the question. Yes, so the question we had is about making sure you have a full team involved. I think that's a great question. So in our practice, and I'm sure others follow this as well, we know what we've presented today. We can help give you the overview of the law and how it works. But the team that we enjoy and we really try to encourage is one that includes the accountant, any kind of life insurance individual, any kind of financial advisor, anyone, bankers, anyone that can help provide a fuller context and approach to the client, we welcome. And I think that it gives everyone, we come into most of our files and to the clients and we know them based on the information. We have some advisors that have been handling the family for generations. And boy, that adds a lot to the equation. And it provides us the ability to really give a full approach to that client. Okay, another question is about how do we protect the asset against divorce? And I think that's a very good question as well. We have had several situations recently, as I mentioned, where the client has the family filed for divorce. And in a family situation, that irrevocable trust, the two barriers, the two things that come up You have the firewall, which is the entity. And then you also have the trust itself that protects it from divorce. And there's nothing better than telling your client when they call you frantic that one of their children is going through divorce and what is the risk to the farmland, to tell them that you're going to be okay because it's not in their name individually.
And it doesn't mean that spouse's attorney won't try to go after the trust assets, things like that, but help our clients.
They will go, we will promise you, they will go after everything. And I think that's very important. And that's the same thing for creditors. As we say, we had a situation where client was in an accident, and no one wants the land. No one is looking for the land, but they want to make sure that they use that to leverage the ability to access the assets. So that gives you some ability to protect it and control it. And I will tell you one other comment that we get, and I'll mention this as part of divorce. There is always a concern, and I think it's legitimate for both husband and wife. What happens if one of the spouses, let's talk about our Mary and Bill. They're happily married, no issues. When one of the family members pass away, you do want to make sure you have a mechanism in place to protect both the land and the entity, and the ability for someone just to come in and intentionally, accidentally take the asset out of the name of the mother and move it into the new spouse's name. I had a case where Liz and I worked on where the family came to us and dad had passed away, mother had passed away. Dad had put together a trust and remarried, and over the course of 5 years, the new spouse had retitled the land jointly with her. So when dad passed away, the land automatically transferred over to new spouse. Now, she may have been thinking this is what she needs to do, but the question is, okay, how do we avoid this going forward? And I would tell you the way we would do it is you can set the LLC up and the trust up so that at the death of one of the spouse, the surviving spouse would be joined by their children. And then what that means is you can't move the asset as easily out of an LLC or out of a trust and into the name of another person.
Well, and I would say that same example or the same thought goes for if someone becomes disabled, because if the familial spouse, the one who would receive these assets, becomes disabled, and their spouse who is outside of the the bloodline can take advantage of them when they're disabled, those same triggers can be put in place in the documents.
That's just so true. A lot of times our clients, and when someone starts to feel like they're losing some control, they could get very more angry at the children that probably have trusted them the most. And so you've got to be careful and you got to plan for that. So that's another important part. And in the family farm context, you got a business going on. And this is very important to think about it and anticipate it. Question about, we got another question here. Okay. A question about the charitable side of things and how that is incorporated. As I mentioned, and we didn't provide some from illustrations, but there's two parts. If it's in your own estate, then the question for that is make sure that you incorporate that so that in the case of Mary and Bill, let's say they have that estate, 28 million, and they want to give 10 million to charity. Well, right off the top, that 20 million is reduced by 10 million. So now you reduced your estate. That's one way you can incorporate planning. A second way you can incorporate planning is if you have in your documents, and this is something that we've done just recently. The ideal situation is always planned with the estate because that's subject to the estate tax. Don't leave anything on the table there. But what if you moved assets into, as I mentioned, the Bide It? So in a Bide It scenario, you move an asset in worth 2.5 million, or let's say it's even more than that. It's currently 20 million and it pops to 200 million. We have clients who say, well, my kids are nice and good and I want to give them something, but I don't want to ruin them. So if they don't have anything in their estate, what we do with the Bided is we give the family the ability to appoint some of those assets in a different direction. And it gives them flexibility because we just don't know how it's going to be in the future. We try to put together these irrevocable trusts with maximum flexibility in mind, understanding, oh, I think we got, I'm not here. I don't know if we have that. I have a question. Okay, we're getting some emails. I'm trying to read it, but that's very important to make sure we are following that and that you incorporate the charitable side on both inside your estate, but we are very mindful for those clients who have it inside their estate to make sure it's also outside their estate.
Exactly.
Okay, so let's go through basis planning. Want to make sure we talk about that. This is also in the cards. You might have, there may be attempts to eliminate the step up. We just don't know. We just don't know. So that's out there. We want to make sure we're thinking about it. If it is, if basis and you do not receive, irrevocable trust assets do not receive a step up in basis. So we do provide that ability to substitute assets within the grantor trust. So that way we're utilizing low basis, moving it back in the estate with high basis assets. And we just don't know how that's going to work. So bottom line, this is kind of this succession action plan that we focus on. First of all, establish irrevocable trusts if we think we are going to be making gifts. Review assets and evaluate and form those entities. And then think about, once they're formed, transferring those assets to the SLAT and to the Bided. You do not want to transfer it outright to a child. You want to make sure you utilize the SLAT or a Bided or an irrevocable trust, but you want to make sure you have some control over that. And then we want to keep your core documents. We're not focusing on that today, but you do want to make sure you have that, you put that in place as well. That's our presentation for today. Any questions? I think we have maybe a few more questions. Let's see. Are trusts protected from elderly care costs? So an irrevocable trust, if you move your assets into an irrevocable trust and you pass the 5-year time period, which is the look back period, then those assets will not be counted for any kind of Medicaid calculation in your own assets. So if you have it protected, it will not be touched. It cannot be touched outside that window. If you have it in your revocable trust, they would be subject to whatever claims any creditor. We try to separate some of that, and that is a benefit an irrevocable trust has, but you do have to be mindful about the look back period.
And Medicaid is also state specific.
And it is state specific. Okay, let's see. Another question here. Okay. So the question is, if you've already implemented everything and you've got that in place, what are the chances that it would be retroactive treatment to go application of tax laws to that? And I think that's slim. Once you've implemented this, the likelihood, I mean, it's going to be challenging for them to do it for this year. If you have already incorporated the planning 5 years ago, 10 years ago, that would be a reach, and it could be unconstitutional, honestly. So those are things that I think that would be unlikely. And that's part of the reason we are encouraging people to do something now rather than at a later time.
Well, and also for the Bideds, you have to get an appraisal or evaluation of the property, by an independent third party and that kind of thing. So any challenges related to those would at least show you've done your due diligence. And
that's a good point. One of the other reasons we encourage maybe doing a gift now versus later is we would report that gift. And under section 6501, you have to report it a proper way. And once you do that, you start the statute of limitations. And I think that's an item right now. If anyone has dealt with the IRS currently, it is a whole new world. I mean, we can't get a hold of them, and it is very unorganized. So I would say, and we are saying, do it now to get the clock running. Eventually, there could be a little bit more of a focus. I will also say, I think we are getting, over the year, I think you're going to get more attention to audits, but you might as well get something done now while there is still a little bit of time to do that. Okay, I think that covers all questions. If we've missed, as we said, if we've missed any question, we will follow up. And if you have questions following this, please let us know.
Definitely. And we thank you so much for joining us today. We hope this information has been helpful to you. If you are seeking continuing education credit, please remember to click on the CEU icon at the bottom of your screen to report your hours. You will also receive a certificate of attendance from our firm by email tomorrow. And please, as Christine mentioned, fill out our short survey so we can know how to work better for you in the future. Thank you again for joining us.
And we are this is new to us, so we do appreciate your feedback. It is very much appreciated, and thank you for joining us today.